has just come down. We used to be honored to go over there. Missouri is the newest one, will not allow us to go in there.
Mr. Williams remains a fugitive. Because the bond was materially changed by this court, I'm going to exonerate you on the bond. Quite frankly, Ms. Moore, the court's disturbed by your Missouri ties. Missouri is less than cooperative. 40,000. We'll see you in March.
They say good fences make good neighbors, so maybe Kansas could use one. Judge Ricke and this bail bondsman have a problem. Missouri won't play ball, and 10 grand of this bondsman's cash is on the line. We'll start with the bondsman who'd love to go pick up his bounty. This lady knows where he is, but she's not saying. She's up after her fugitive boyfriend, here for sentencing on a drug beef. Judge Ricke has a few things to say to her about her missing man. Following those, you'll see another hearing before Ricke and find out why the state of Missouri just set fire to this lady's get-out-of-jail-free card. Let's roll, nerds.
State of Kansas versus Robert Lee Williams. I have some people at the Greenwood County Courthouse. Neither one appears to be Mr. Williams. Who do we have?
Yes, sir, Judge Ricke. My name is Randy McCarty. I am the owner of Bad Boy Bail Bonds.
Your Honor, my name is Quinn Duncan. I'm an agent with Bad Boy Bail Bonds. Good morning.
Morning. The matter before the court is for this court to consider granting judgment on bond in the amount of $10,000 due to Mr. Williams' previous failure to appear on November 12 of 2025. As far as I know, he has not been taken into custody subsequent to that date.
I was on VineLink just a little bit ago. He is not in custody anywhere that I know of.
All right, Mr. McCarty, Mr. Duncan, do you have a presentation to make to the court about this?
Yes, sir. I thank you for your time, Judge. There's a couple of things. Upon executing this bond, it was the understanding of the surety company that on the special conditions on the bond was no contact with Jessica Heath and Kaylee Little, and there was also a stipulation that must have GPS. And we contacted the GPS company. That was all coordinated. But in the time of the GPS getting over here and getting a monitor on this defendant, they moved him to Harvey County without his GPS on. And then as soon as he got to Harvey County, they OR'd him out. And another deal, we wasn't notified that he had missed court through any type of mail service, no certified letter, whatever. But that's beside the point, because I'd gotten on the portal here a few weeks back and seen that he had missed court. So we started, working on this, and we've exhausted our avenues. It seems as though he fled. He got back with Jessica. It's our understanding that he's over in Missouri, which Missouri does not allow us to come over there and do any type of fugitive recovery. And so our hands are really tied getting him back over here and honoring the court system.
All right, so how do they expect you to be able to take these people into custody? Use one of their in-state agents to do the work?
No, they have to, but then they can't cross them. They can't cross them over to the Kansas line. There's law now that they just implemented this, that the agent, if a Missouri agent can't transport a defendant over the county line either. There was a kidnapping charge against an individual over in Missouri that, and we learned this at our last continuing education class. And all his documentation, the defendant, it was all Kansas-based, Wichita. And even though he had another address up in Iola, we were banking on the GPS and to be able to monitor this guy, and which we do. We monitor, and we definitely are appreciative of the courts when they mandate a GPS to be put on an individual. It just makes our job more secure, and it gives us a heads up if they do cut the bracelet off or whatever. And there's another line of defense of their information that they give to the GPS people. So I would really look, if it if the court would honor my request of, I would like to be exonerated off this bond as a result of, A, I can't go over and pick him up, and B, we released him without putting a GPS on him.
I'm a little curious about your assertion that he was released without GPS. There was clearly a GPS requirement when I lowered his bond to $10,000. He was to be in Allen, Woodson, or Greenwood counties only.
Yes, sir.
So are you telling me he had a hold from somewhere else and then he went to Harvey, and then when they released him, he didn't have GPS?
Well, he was to get his GPS here in Greenwood County.
Mm-hmm.
And Greenwood County released him without his GPS on.
Actually, on September 11th of 2025, there was a motion to the court in front of Judge Ricke, and the motion was granted to not have to be on GPS at that time. And then he continued on bond without GPS at the order of the court from September 11th, 2025. And then he appeared before the court November 6th, and then he failed to appear November 12th.
Well,
So it was actually court ordered that the GPS could be removed September 11th, 2025.
That's true. That was done as part of the hearing on the suppression motion. So as of that date, he didn't have a GPS requirement, though
Yes.
in retrospect, he probably should have. On the other hand, as we all know, Mr. McCarty, defendants are famous for removing those devices when they want to leave the state.
yes, sir.
That shouldn't become as a big revelation.
Yes, sir. Yes,
So
sir.
I do appreciate you just dealing with this head on by appearing and addressing the court today. I do not understand this Missouri rule. I don't know how they recover their people from other states, or do they not care if the people on their bonds abscond? I mean, I trust it swings both ways in Missouri. That I just don't quite understand this rule where you can't go get him. What part of Missouri do you believe he's in?
That address is Crest Drive in Summit, Missouri. And there's also a lead that I worked on in Grandview, Missouri. Back to that, if I may, Judge, if we can back up to the bond I signed, and the bond that I agreed to be on mandated GPS. And if when he showed up for court and the courts reversed that and decided to take the GPS off, I believe that I should have been able to have the option to sign a new bond, because I would think that if this particular bond that I signed has been modified, I shouldn't be responsible for a modified bond that I didn't sign.
I'm going to pull that up.
Yeah, because the bond I clearly signed, or my agent signed, clearly said must have GPS. And I realize that they can cut them bracelets off and what have you. And at that point, we are notified immediately that a bracelet has been tampered with, and it does give us a head start to be able to locate the fugitive. But if a bond's been modified, that's not the same bond that we agreed to support and honor.
And so you're telling me that your agency wasn't notified that change had been made?
No, sir. Absolutely not.
Well, that's a material difference that makes a difference in the view of the court, Mr. McCarty. Your point's well taken.
Yes, sir.
He was ordered to have GPS originally, and that was endorsed on the face of the bond itself. I know I've warned more than one defendant that when there's been a change in the bonding requirements, that I've advised them that your bondsman may go ahead and surrender you to the jail, because that's different than the bond that they agreed to be on. I don't know if that was done here or not. I'd rather you be able to tell me, gentlemen, that you've got a lead on him and you're going to have him in custody in a couple of weeks.
Well, as of right now, we've exhausted everything that we can possibly do here in the Kansas area.
Okay. Well, I was also going to ask you about this. Can somebody in Missouri pick him up, take him to the Kansas line, and then you take him, meet at the border, and can that be done?
Well, he can't, the Missouri people can't go over into Kansas,
Okay.
and Kansas
They go right
can't.
up to the line, and then you go right up to the line and you switch him.
There's some discrepancy with that, Your Honor, and that law has just come down the pike here this last year. You know, we used to be honored to go over there, and there's some of these states that are hindering our ability to go into their state and retrieve these fugitives. Missouri is the newest one. The Texas, Louisiana, and some northern states as well will not allow us to go in there. It's all done through their system and the process of extraditing. And in this case, we don't have an extraditable warrant. It's just local warrant. It's not a statewide warrant. And it's my understanding that Butler County is not going to go get him if he's off in Missouri. And I want to think I've always honored the court system. I've been at this for 25 years. And to be honest with you, I haven't paid one off yet, and I haven't lost one. And, you know, sometimes the things we got to do to get people to do what they don't want to do has not always been pretty. But I still got to obey the law, and I can't go in there ramrodding and trying to yank him out of there.
Well, you could, but you'd be doing that at a certain amount of legal risk.
Yeah, I think my wife would be upset.
We don't want to cause that under any circumstance, Mr. McCarty. Well, I agree with your position, Mr. McCarty. I can't particularly say that I like it, but I agree with you that there was a material change in the conditions of the bond that, in this instance, made a difference. And when this court removed the GPS requirement, I think to give a financial break to Mr. Williams, and I think at that point he had appeared on his own. And the court felt like that the financial burdens that were going along with GPS could be removed at that point, but it did materially change the bond that you thought he had. And I agree with you that had he kept GPS monitoring on, you may have been in a superior position to do something upon his failure to appear. Because the bond was materially changed by this court, I'm going to exonerate you on the bond. You and Mr. Duncan, Mr. McCarty. You remain in good standing in our court. Wish I could say that about all of the bonding authorities in our district, but I do agree with your arguments here. So you're exonerated on this bond. Mr. Williams remains a fugitive.
Yes, sir. Thank you,
Right.
Your Honor. I would like to add, it's my understanding too that he is back with Jessica. And so he is completely violating those other no contact orders. The investigating that I've done, there's documentation through Facebook, dated pictures, and what have you. And so I'd like to share that with the court system too, that he is just disregarding any stipulations that was on his bond and the leniency that the courts, you know, I know you lowered the bond and tried to accommodate this man to turn things around. And I would just like to say that it's obvious that he has no regards for the court systems, and that's just too bad. A man 52 years old, but you know, we run into this all the time. You do, Judge, and I just wanted to share that with the courts.
Well, I hope if the county attorney's office or sheriff's department needs some further information that you may have in your files on this guy, that you'd be glad to share it.
Yes, sir.
Yes, sir.
Let's just say he's in trouble in the state, and I don't want you to go down with him. Jessica Rochelle Heath. This matter came before the court on December 4, 2025. At that time, defendant entered a guilty plea to count 2, unlawful possession of a controlled substance, methamphetamine, a level 5 drug felony, and count 5, unlawful possession of drug paraphernalia, Class B misdemeanor. Court ordered a pre-sentence report and set sentencing for today. Court will adopt the criminal history as stated in the report and finds that the criminal history score applicable to the primary count in this case is criminal history score H, and the court will proceed further accordingly. Ms. Gillette, do you know of a legal reason why sentence should not be pronounced in the Heath case here today?
I do not, Your Honor.
Mr. Favre, are you aware of any such legal reason?
No, Judge. Judge, we agree with all the recommendations in the PSI. Ms. Heath is presumptive probation, mandatory Senate bill, 183 days of jail credit, 18 months community corrections probation. We would ask that the court run counts 2 and 5 concurrent to one another. No issue with any of the recommended probation conditions listed in the PSI. I would note for the court that Ms. Heath is currently going to treatment, has been going for some time. She goes to Knox Treatment Center twice a week. I don't know how that would comport with her requirements for Senate Bill 123, but if that would work out, then we ask that she be allowed to continue doing that treatment. It seems to be working for her. She is currently working at a Burger King in Wichita. She just started. She makes $11 an hour, and she's just in training. So
Thank you, Mr. Favre. Your fees and the representation of this client?
I don't have a total. My guess is somewhere in the range of $1,000.
Thank you. Heath, at this time, the court will address you personally and ask you if you have any statements that you wish to make in mitigation of punishment or anything further that you would like to present to the court.
Other than, like he said, I have been going to treatment with Knox, and I did my drug and alcohol evaluation with them. Can't remember what day exactly it was. I got my paperwork here. I think it was on the 18th of December was when I did it. Yeah, on the 18th of December is when I did my drug and alcohol evaluation with Knox.
Okay. Where is that facility located?
It's on Douglas and Hillside in Wichita.
Okay. All right. Ms. Heath, anything else?
I don't believe so, no.
Very well. Court will announce sentence at this time. The court hereby sentences the defendant to the standard term of 13 months in the custody of the Secretary of Corrections, the state of Kansas, regarding the additional offense in count 5, a possession of drug paraphernalia. The court will impose 6 months in the Greenwood County Jail, run that time concurrently with the time imposed on the felony count. The defendant is ordered into substance abuse treatment and or community corrections probation for the 18-month period. The defendant is specifically ordered to have no contact or communication whatsoever with co-defendant Robert Lee Williams. All right, Ms. Gillette, are you aware of sentencing-related matters which the court still needs to address?
Judge, is this consecutive or concurrent to the Harvey County misdemeanor case?
The court's order contemplates concurrence with any previous conviction. Ms. Heath, I've got one more matter I want to address with you.
Okay.
I had a hearing this morning on Robert Lee Williams, who you are not to have any contact with. In fact, he's not to have any contact with you as a condition of his bond, which he has violated. He is currently in an absconder status, and the information received by the court this morning is that he has left the state. Yet, he is still having contact with you. Now, again, this is third-party information, but I sure hope you're not having any contact or communication with Robert Lee Williams, because he is an absconder, and let's just say he's in trouble in this state, and I don't want you to go down with him.
I understand.
So that's why I very specifically mentioned that you're to have no contact or communication whatsoever with Robert Lee Williams. I would consider that a very serious violation of the terms and conditions of your community corrections placement if you violate that. Understood?
Yes.
Missouri is less than cooperative Case entitled State of Kansas versus Leanne Moore. This matter comes before the court at this time as the court understands it for arraignment. So following preliminary hearing, waiver arraignment was set for today. So we're proceeding under the amended complaint. Now, apparently what's contemplated to be done then is that the defendant would be accepting conviction by entering a plea of guilty then, Mr. McClendon, to count 1, organized retail theft.
Yes, Your Honor.
All right, Ms. Moore?
Yes, sir.
All right, it's court's understanding that you'd be resolving your case by entering a plea of guilty to count 1, organized retail theft, a level 6 non-person felony. In return, the state would be then, I guess, dismissing all of the misdemeanor charges.
Yes, sir.
All right. Are you aware of the possible penalties that could be imposed as a result of this guilty plea that you are attempting to make?
Yes, sir.
Okay, you'd be on level 6 of the non-drug offense grid on this level 6 organized retail theft charge. In the most favorable criminal history category of I, you could receive as little as a 17-month sentence. In the worst criminal history category of A, you could receive up to a 46-month sentence. So the sentencing range is 17 to 46 months in prison, depending on your criminal history. As you participate today, we do not know with certainty what your criminal history is. You better than anyone else here, Ms. Moore, should know what your own criminal record looks like. But that will be researched by the Court Services Department, and based on the outcome of their research as of the date of sentencing, that determines where you fall along the level 6 line, and then you'll be sentenced accordingly. Do you understand that?
Yes, sir.
It's important for me to point out here, Ms. Moore, that if you have a felony on your record already at time of sentencing, you would be presumptive prison here. You understand that?
Yes, sir.
Ms. Moore, do you understand that if there are any plea agreements between your counsel and the county attorney's office regarding sentencing recommendations, that this court is not bound by any agreements made? The court may and shall consider them as recommendations, but is not bound by them. Do you understand that?
Yes, sir.
So let me ask you how you formally plead to the charge in count 1 of the amended complaint, level 6 non-person felony, organized retail theft.
Guilty.
According to the state's charging document, this took place about September 24th of 2025. Is that when it happened?
Yes, sir.
It happened somewhere in Greenwood County, Kansas. Where was it?
It was at a local farm store
Local where?
here in Eureka.
Okay. Okay, what did you do that would constitute organized retail theft?
I tried to steal, or I was going to steal a Milwaukee battery and a Milwaukee drill.
Okay. Did this have an aggregate retail market value of over $5,000?
I'm not sure, Your Honor.
Was this part of an organized plan involving one or more retailers to commit theft?
Yes, sir.
Would the state's evidence show, Ms. Gillette, that this $5,000 or more threshold would be met?
Judge, it would show that there were 3 thefts in the Eureka area, 2 at Home Lumber, 1 on August 25th, the other on September 24th, 1 at Tractor Supply on September 24th, Tractor Supply in El Dorado on September 24th, Bumgars in Hillsborough on September 24th, Ace Hardware in Merriam on September 23rd, Atwoods in Andover on May 11th, and Atwoods in Andover on May 17th, and Home Lumber and Supply in Winfield August 5th. The grand total and aggregate amount of the thefts are $14,168.70. There was also a juvenile being used as a distraction and help aid in the organized retail crime across this part of the state of Kansas.
So, Leanne Moore, are you entering a plea of guilty and accepting conviction for organized retail theft freely, knowingly, and voluntarily?
Yes, sir.
Court will accept the guilty plea made by the defendant. Court finds her guilty. The judges her convicted of organized retail theft. All other charges of the information are dismissed pursuant to plea agreement. Court orders a pre-sentence report be completed to accurately determine Ms. Moore's criminal history. Sentencing is set for 11 o'clock a.m. Thursday, March 19. That's contemplated to be done by Zoom. So 11 o'clock, Thursday, March 19. Defendant must obviously fully participate in that sentencing proceeding. Also, the court will order the defendant to comply with any pre-sentence assessments that she's asked to do.
Judge, may I be heard on bond when you're ready?
Go ahead, Mr. McClendon.
Yes, Your Honor. My client's been in custody since the inception of this case, which has been since I believe the beginning of September at least. She's been unable to make bond, and she'd like to be able to bond out here today. We'd be requesting a bond modification to $5,000 cash or surety. I do not know what it is at this time. I believe, if I recall, it's about 25 or 30,000. It is quite significant.
Looks like 40 was set at first appearance. 40,000.
Okay.
Where does your client live?
She's from the state of Missouri, I believe. Is that right, Ms. Moore?
Yes, sir. Crane, Missouri.
It is my preference that defendants stay in the state of Kansas while their cases are pending because it's so difficult to extradite and bring people back from other states. I continue to have some concerns about the minor child being used in the criminal matters as to contact with the minor child if she's out. But as far as the bond is concerned, if it's lowered, I still ask that it remain a cash surety bond and that she remain in the state of Kansas.
Court has considered the bond reduction request and the court will deny it. Quite frankly, Ms. Moore, the court's disturbed by your Missouri ties. The court received information this morning that would seem to suggest that Missouri is less than cooperative with Kansas bondsmen if they have to try to retrieve someone from that state. So I'm insecure. You're facing potentially a prison offense here. I'm going to leave bond where apparently originally set, or I'll establish it or reestablish it at $40,000 cash or a professional surety required. We'll see you in March, and then we'll talk about the potential of release at that time. $40,000 cash or professional surety required. And if she does make that bond, she will have a strict GPS requirement where she would not be able to leave the state of Kansas. All right, with her bond situation clarified and the plea taken, if there's nothing further, counsel?
Nothing for me, Your Honor.
All right. Then the Leanne Moore matter will currently be in recess, and this meeting may be ended for all.